Hi everyone, I'm Jake, one of the attorneys here at Denman Perlman. I represent people in criminal defense cases, and I'm here today to talk to you about some common myths or misconceptions that people have when they're going through the justice system. So starting off with one of my favorite myths, I get this one regularly. It's Mr. Pillsbury. The officer didn't read me my Miranda rights, so that means that my case is going to get dismissed, right? Wrong. No, that's not the way that works. Unfortunately, the officers are required and encouraged to read you your rights, specifically your right to remain silent, your right to have an attorney represent you throughout trial and be present for questioning. But that doesn't mean if they didn't do that, that your case gets dismissed. No, all that happens is if they interrogate you without telling you those things, your attorney may have the option to get those statements suppressed later on in your case. The second myth that's pretty common in cases involving domestic violence or other types of violence cases is, well, Mr. Pillsbury, the victim doesn't want to pursue charges here and isn't going to press charges, so I don't have to worry about this, right? No, that's wrong again. Unfortunately, the victim of the case doesn't get to decide whether the state presses charges. So when a charge is brought against a criminal defendant in the state of Florida, the people who bring that charge are the prosecutors. Now, the prosecutors take into consideration whether a victim wants to bring a case, but they're not bound to that person's wants. I can't tell you the number of cases I've represented people where the victim didn't want to pursue charges. I've even had trial cases where I've gone to trial and had to represent somebody who the victim testified they didn't want charged. But it's still something that the state can and will do. Now, moving on to number 3, the third myth that we're discussing today is, well, I blew triple zeros, and if I do blow triple zeros, Mr. Pillsbury, that means they'll let me go, right? Wrong. Absolutely not. If they're asking you to blow into a breathalyzer machine, you have already been arrested. That means you're already going to be charged with DUI no matter what. All that's going to happen if you blow triple zeros is the officer is going to turn around and ask you to pee into a cup. That's right, you heard me correctly. They're going to ask for a urine sample as soon as you blow. The fourth myth that we have here today is, Mr. Pillsbury, don't the police have to be honest with you? Like, cops have to tell you they're cops if you ask, right? No, man, come on. We all know that's crazy, right? I mean, that reminds me of that scene from Breaking Bad where Badger's sitting on the bench and the cop's sitting next to him, and they go back and forth, and the cop convinces Badger that he'd have to tell him he was a cop, and that's not really what happened, right? Badger got arrested immediately after selling that dope. So if officers had to tell you that they were officers, no undercover investigation would ever work. So don't fall for that trick. And number 5, the last myth that we're going to go over today is, I can't be found guilty of DUI because the car wasn't running, right? Wrong again. Unfortunately, in the state of Florida, a DUI, you can be found guilty of DUI for just being in actual physical control of a vehicle. Actual physical control doesn't require that the vehicle be in motion, that you be driving the car, or even that the keys be in the ignition. If you have the ability to operate that car, and that car can be operated by somebody, and you're sitting in that driver's seat, you better believe they can find you guilty of DUI. So that's the 5 myths we're here to talk about today. It's certainly not every myth I've heard, and I expect to hear a lot more in my career going forward. As a matter of fact, if you have any myths or misconceptions that you think are common about the criminal justice system, I'd love to hear about them, so leave them in the comments below.